In the spirit of trying to take care of things, let's see if we can take the governor's roundtable at this time. This is an agenda item set for tomorrow. We want to take care of it today. All right, Governor Williams-Root. Oh, sorry. Okay.
Thank you, acting President, Treasurer Ottawale. I am actually just here because it is a big month of MBA events happening, and I just wanted to bring two that I specifically know about to the attention of everyone and remind you that these can be events attended that the bar will help cover costs for. One is the Q Law Annual Banquet on May 30th. Its theme is it's the 19th annual banquet, and it's called Back to the Future. It's held in Seattle at the Bell Harbor International Conference Center at like 5 p.m. or 5:30 or something like that. The other one is a very cool, and I'm going to pull it up. I was invited to attend the Lauren Miller Bar Annual Scholarship Banquet, which is the next day, May 31st, 2024. It's the Philip L. Burton Memorial Scholarship Dinner. Again, if you're interested in attending those, you can reach out to the Lauren Miller Bar. You can reach out to me. I've got the link for tickets. And so I just wanted to, again, remind people that that May for many of our MBAs is the end of their year. And so there's a lot of celebrations, and they do appreciate seeing us at their events and getting out and being present just outside of the working meetings as well. So thank you so much, and I hope I can look forward to seeing some of you there. Bye-bye.
Thank you. Governor Kari Petrasik.
Thank you. One of the constituents in my district has brought this issue to my attention and inquired about whether it would be possible to add pronouns to our profiles on the WSBA directory. I think it makes a lot of sense, and in this day and age when people have names that could be male or female or are entirely neutral names, like I know someone named Sky, I think it's important. This person indicated that in our profession, we like to address people by Ms. or Mr. so-and-so. And this would enable her as well as all the rest of us. And I would think that this could be another thing that could be an optional ad. People could opt in, or if they wanted to do that, similarly to whether or not you want to have your malpractice listed on your WSBA profile. And I believe Communications Director Nagowski might have a reply to my request if she's here, which I don't think she is. So
can I see Diana has come on. I want to just acknowledge that Governor Williams-Ruth made this request, I think, well over a year ago, maybe even 2 years ago, and we have been working on it. We've run into a few things that have sort of been hotly debated internally, but I think Chief Singleton is able to give an update at where we're at.
Yes, I was just going to let you know that we are moving forward with making this happen. It's now being worked on with RSD, the Regulatory Services Department, in partnership with our IT. So we have to do the behind the scenes things to have it up online and that sort of thing. So Selena has been working with a group of folks internally to operationalize what you had just suggested.
Governor Petrasik.
And then secondly, as chair of the STAR committee, hopefully you've all seen that we have an inaugural summit on June 7th at Gonzaga Law School. Many thanks to Lori Powers for helping set that up there. But I would encourage all of you to attend if you can. It's going to be a great event, and we'll be having very in-depth discussions with judges, attorneys, law students, legal service providers, you name it. They'll be there about ways that we can improve law students and increase law students going into rural areas.
Thank you. Any other, Governor Jordan Couch?
Like I
And
said,
then-
it's the Brent and Jordan show today. So one thing I kind of wanted to ask a question on, kind of hear perspectives that of those who I suspect know a lot about this. With our true president behind the scenes now, as he's had to leave and step down. I'm curious, as I was looking over these, like the bylaws as we have them prohibit us from supporting candidates for office where a lawyer is a requirement for the office, including things like contributing funds or participation to support to any degree in the candidate's campaign. And I was wondering about this and if there's reasoning behind this, because it seems pretty extreme as I'm thinking about it. Like I was wondering myself, Sal, I can support Hunter right now, but Sal Mungia, who's running for Supreme Court, I don't always track if our firm makes donations to campaigns, but we do sometimes. So if Patrick's like donated some money to Sal under the firm, I violated this rule without even knowing it, because I'm not tracking our charitable donations well enough, because we tend to agree on these things. And I think, I don't know, I'd be curious to explore if these rules are serving a valuable purpose, or if they are restricting our speech unnecessarily. We are people who people turn to sometimes for these questions. And I think about, like, if, friends of mine ask who they should vote for on the Supreme Court, which they often do, or various judicial positions, they often do, am I required to be silent or answer questions? And I think, yeah, it's a strange rule. I'm curious just if there are perspectives on this.
Yeah.
Let me just.
Yep.
Lisa Amatangel, thank you. If I understand the question, is whether we are aware of the background of these particular rules that you just mentioned, and I see that you're eating.
And it's serving a valuable purpose.
And I would be glad to look into that. Yes, thank you.
Good answer. Past President Dan, I know. Okay, with this, a response to this. Okay.
Yeah, so I think the rule exists so that, one member doesn't feel like their bar is like, I ran against Sal, right? And you all back Sal, I would feel like, well, wow, thanks guys, kind of thing, right? So I think that's why the rule is there. That's it. So thank you.
All right, thank you. Governor Mary Rathbone.
Thank you. I actually was looking forward to the roundtable this week because I have a few things that I wanted to address. So I have two things, and I'm saying that so I remember the second. Number one, I hear a lot of discussion, and I haven't had the opportunity to be on the DEI Council, and I'm hoping to make my way there eventually. But I hear a lot about access to courts, access to justice, how it's important. Here's my issue, and it comes from my personal experience, unfortunately, but I imagine that you wouldn't have want me sitting in this position if I wasn't going to apply my personal experience. And what I'm seeing in my practice is that to a certain extent, access to justice is being impacted by the inability of the courts to communicate. And what I mean by that is you have your judges, you have your clerks, you have your JAs. I wouldn't say that they're necessarily the most cohesive group. I would say that I would like to think that they are. But what it comes down to is, even if you do everything right, it's all subjective to the person that you're dealing with. And I'm seeing a barrier to access. And so how do we address that, I guess, is my question. I see a lot of this when things happen. As lawyers, we are at the behest of the courts. So it's not necessarily the greatest thing to do to call someone up to tell them how they didn't follow the law procedurally, only to have no avenue or no way to fix the system. Simply, you're just sitting with what you're stuck with. And I don't think that that's what the system was designed to do. So I wanted to bring that to the attention of everyone because I think it impacts one of our core values, which is DEI and access to courts. So again, just kind of addressing that generally, I'm not going to call anyone specifically out right now, but if you get me more mad, I might. I think where I just would like to see where we can open a discussion is what is the court's buy-in and their pathway to open access to their very own doors? And are they addressing when they are implementing rules, the DEI parameters? And are they trying to be diplomatic? Are they supervising their staff, and are the departments cohesively working together in a way that is considering access to courts? And based on my 2 experiences this week in 2 different counties, I don't think that that's true. So that's all I'm going to say about that. Number 2, I had the opportunity to speak to some high school students this week at Vanguard Academy. So to explain Vanguard Academy, essentially, they are a school. It's not an alternative school, but it is somewhat, it's sort of a hybrid between a trade school and traditional school. I don't know how else to explain it. And in my conversation with them, I got 50 minutes to talk to these kids about being a lawyer and what it means and what type of law I practice. And after we got over the questions about, is it like Suits? Is it like Law and Order? I really turned the discussion on them to say, hey, guess what, guys? I'm going to go sit at the Board of Governors meeting this weekend. What are some things, or we're still in the week, what are some things that you want me to take back? And I preface the question by saying, our profession needs more lawyers, and we want to lower our barriers to the practice of law to make it more inclusive. So keeping that in mind, what do they want? What would you want me to tell my board when I go and meet with them? And I got a lot of really good feedback. And essentially what it boiled down to is the classic issue: attorneys are not accessible. And I think when I discussed it with them, they said, I've never spoken to a lawyer. I've never had a lawyer take the time to speak to me. And so really what they said is, we just want more information. And so you see, I thought about solutions because I'm a solution-based person. And I guess my thought was, why don't we as attorneys, at least through the Bar Association, have some sort of high school level clubs, right? To at least start access, not just from a private school in Seattle. I didn't have a debate team when I grew up. I didn't have a mock trial team growing up. I was just left to arguing with my dad at the dinner table. So I think, at least as far as, are we creating those programs so that we're feeding into our profession in a meaningful way, starting at a young age? So that's the other thing I wanted to bring to everyone's attention. And I guess there's 3. There is a free legal clinic in Mattawa on May. Let me pull up the calendar. Let me pull it up. Sorry, please hold. May 4th, which is Saturday, and they, at least from my knowledge, needed lawyers to participate. I attempted to get this information out locally, and it was not disseminated, but I tried to send it to as many people as I could. So if you're available or have questions, it is through the, another thing I should know, right? It's through the Yakima Legal Services Clinic. What? Yeah. Okay.
VAS.
Thank you. VAS, VAS. So I just wanted to bring that to everyone's attention. Thank you.
Governor Williams-Ruth.
Thank you, Acting President Angelville. So first, I just want to respond to a couple of things to Governor Rathbone's. And the first is, Not one of those students mentioned Ally McBeal, The Practice, Matlock, LA Law, or Perry Mason, or Boston Legal. I mean, Denny Crane. Anyway, I guess that's just showing that I'm of a certain generation now. The senior section will be calling me shortly. But to be in all seriousness, the issue about the courts, and I'll use one of my examples. And again, if anyone wants to take this on, I believe it's perfectly germane and would be within our bar rights, but it's the unified court system. And for me, it was the first time I ever appeared in Pierce County to open a probate, where there is an unwritten rule. There is no rule written down anywhere that you must provide the birth date of your presumptive executor. And if you don't, they will reject your pleading as non-compliant and send it back. And I'm like, I'm sorry, did I miss a local rule? I'm usually really good at reading local rules. No, it's just that is a requirement of Pierce County courts. And the problem for those who do not know the way the unified court system works, that's where every court in the state is subject in one silo to the Supreme Court all the way down to your district municipal judges. And Washington does not have that. In fact, our county courts are provided for in our Constitution, specifically the court clerk. And the issue that I have run headlong into and keep banging my head against the wall is that there are 42 county clerks, and they are their own lord and ladies of the manor. And they would have to give up that power that they have over their fiefdom to have a unified court system, which is why unless we actually get a actual coalition together to show why these issues that I've encountered, and it sounds like you're now encountering this last week, you are going to have these inconsistent rulings, inconsistent application of non-existent requirements, where no attorney doing their due diligence can even find out about it until you've done it wrong and cost your client more money. I will also say that I enjoy my practice of estate administration because to close an estate administration, there are 4 required disclosures that are public. The amount of money paid to an executor for their service, any appraisers that were hired and how much that cost, any tax professionals, and legal fees. I really wish we had a requirement that at the end of every action, the lawyers were required to disclose how much they were paid. So someone could look if they wanted to and say, oh, hey, this was a four-year trial with 632 things in the docket, and it cost $742,000 in legal fees. Because I am encountering situations where people don't know what they're getting. And I'm grateful for the fact that I have this ability to, as I was advised by our prior general counsel, get around antitrust laws by talking about the average cost, because it's a public document. You can go and look at all 125 of my probate cases and see exactly how much I was paid. And you can look at the docket and you can say, hey, this was a simple probate and this is what Brent charged. You know, I really do wish that we had that, because as you're dealing with these students that have never encountered an attorney before, how do they know when they go to someone, and again, it's not easy to call around and spend money, even if you can talk to an attorney that will give you a free consultation. I realize that in my area of law, that's getting more and more rare, that someone will do a free consult, that they don't know that you shouldn't have to pay $752,000 for a case that has $4,000 in controversy. Again, I'm being hyperbolic there just for the sake of demonstration. So I appreciate you bringing those comments. I too echo them and hear them in people who are not the legal profession. And I wish there was a way we actually could take those steps, because those are the small steps that lead to access. Thank you.
Thank you. Chief Nagowski, and then Governor Couch, and then Governor Fay.
Tara rolled her eyes.
as soon as Mary got on this, and you heard me whispering over here, I am not supposed to have a soapbox, but I do. And it is this: if you asked me after going on many listening tour stops, whatever, many, Brent has been with there. Inevitably, I think we even got it when we were up talking with you and Everett, like inevitably, it boils. Look, I'm telling you now, Kari, it is a unified court system and it comes out in different ways. It comes out mostly as access to justice. It comes out to, I can't practice there. I'm charging my clients because I have to do this. And it really strikes me as something very unique to the organization that represents the legal profession that has the biggest stake in that, because we are using the various rules. It's not the courts who love their individual fiefdoms, and it's not the public who has no idea the harm it causes. And so I don't know if I just sent Tara running for the hills, but I have non-facetiously said, what are some bites that we can begin to take? Because this is a huge topic. And I also believe it is the number one topic when I go out, when you hear back from people, that it would actually make their lives serving clients indescribably easier, because all of the inconsistencies and discrepancies don't benefit anybody. So stay tuned. If anybody wants, we also are talking about things that would be germane, as we're saying, about, some kind of legislative arena or something that we could really look at. We do a lot of different pieces and areas of topics of law. But I don't know. I don't know if there's a will. I don't know what that looks like. But Mary, you can tell you lit a fire, and I think Brent's with me. It's a big topic.
Thank you. Thank you both. And I'm sorry, Chief Singleton, I had not seen your hand raised. I think you actually are next, and then Governor Fay, and then Governor Couch. So go ahead, Chief Singleton.
Thank you so much. I appreciate it. I just thought I would add to this conversation, which I'm really grateful for Governor Rathbone bringing this up as it relates to access to justice. And as folks remember, back in January, the Access to Justice Board met with you, their annual meeting, and you had a discussion about how you can partner together. So I just wanted to remind you that the Access to Justice Board, the ATJ Board, is actively thinking and considering and trying to collaborate and work on these systemic issues. And so just so you know, you're welcome to, if you have specific things about something you're seeing in the court about fees or people not accessing the system because of technology, the ATJ Board has 3 committees that are actively doing work. One is the Rules Committee. So they look at proposed rules, and in fact, they just voted last week to submit a number of comments about rules about remote court proceedings. So they have a Rules Committee. They have a Technology Committee, and that committee is actively seeing how, for the most part, technology creates a barrier for litigants and communities to access the court system. And they try and, keep a careful watch on how courts are using technology. And I think for the most part, they're trying to use it to create access, but oftentimes they may inadvertently create barriers. So that's a committee that meets regularly. And then they have the Delivery System Committee, or they call themselves DISCO. They're a fun group. But that's basically most of the civil legal aid providers in the state, and their meetings are designed to not just figure out how they're going to coordinate and work together, but also identify emerging or systemic issues that they're seeing across the state. So anyone is welcome to attend any of these meetings, committee meetings that they do meet regularly. And if you're not able to, I'm happy to pass on specific issues that you're seeing. And then if you want to come to a meeting to present on that or to ask them what they're doing, you're welcome to. And then I also just wanted to mention that the Administrative Office of the Courts, they have a relatively new team or program called the Court Equity and Access Program. And they just got staffed up probably in this last year, although their director's about to relocate, so they're probably going to need to hire again. And I'll send a link to share. They have a overview in a publication sharing about what they're planning on doing, and they're just concluding a process of getting input around their strategic plan. But that might be an entity that the Board of Governors might consider asking them to come to a meeting to share about what they're doing. So you can learn what's happening from their perspective, and maybe there's areas that you could partner with. And then the last thing I'm going to say, switching directions to what Governor Rathbun was sharing about your visit with those students, which is amazing that you spent that much, that time to meet with them. I think it's those moments that can, plant those seeds or create those sparks for those students that you're meeting with. But I wanted to mention that the DEI Council over this last year has been working toward what's being called a Pathways into the Profession Summit. And we have a great group of DEI Council members, as well as other volunteers, in addition to those members who are working to plan this summit, which is scheduled for September 12th. And we're figuring out the details, but it'll most likely be at Central Washington University. With a hybrid option. And the idea behind this summit, the reason why the council wanted to do this is all these questions about, how are we making the profession accessible, and really thinking broadly about what does that mean, not just in a pathway through law school, but other pathways as well. And really trying to think about what is the highest and best use for the Bar Association in this in the work that is happening. So the idea behind the summit is to bring together people from all our state who are already doing this work through pathway and pipeline programs, and others who have been sort of left out, and to create conversations to identify, one, how can we learn and work together, and two, where are the gaps and where can the Bar Association really invest in working towards those issues that you were mentioning. So that is all, but hopefully that was helpful to this conversation.
Thank you so much. And next we have Governor Couch, then Governor Fay, and then Governor Ahern.
Chief Singleton stole my thunder a little bit on this, but I was going to say these questions around courts are really important. I had my own frustration on a case last week with a judge. I felt like wasting everyone's time. But the Access to Justice Board is working on this, and unfortunately fortunately has its tentacles in all of the different organizations that are involved in these conversations. The unfortunate part is how many different organizations are involved in these things that gets it really complicated. And I think if we want to start, as I think Governor Adewale put it in his campaign speech today, being that voice, being that advocate, stepping in when the state bar needs to step in. The Access to Justice Board does amazing work, but I think there is a disconnect there between the authority that the state bar has. And so one thing I think we could probably do in the next year and to help with these issues is connect ourselves more with the Access to Justice Board so that we can be the voice when they need us to be the voice, when we can stand up and fight for these things as well, and say to AOC, say to the local court clerks, these are things that have to happen. This is not an Access to Justice Board. This is the state bar saying this has to happen. So the more connection we could have with them, and perhaps a regular meeting every year or some regular check-ins. I know we have liaisons to the Access to Justice Board, but the Access to Justice Board has liaisons to all of the different court entities and clerk associations and all of these things. They are a great group to be involved with on this. In fact, even the technology committee, so a subcommittee of the ATJ board, had regular reports at every meeting when I ran it from each of the different liaisons who are focused in technology, talking to these different groups. There's a lot going on there. And I think we don't need to redo the work they're doing, but I think we should reach out and see what we can do to be the voice they need to actually affirmatively put some more teeth behind the things they would like to be doing. Great organization. Francis came from there. Christina came from there. I was an underling there. So, yeah.
Thank you, Governor Couch. Governor Fay, and then Governor Ahern.
Well, I want to first of all give a shout out to fellow Governor Williams-Ruth with the problem he had in Pierce County. I too had a filing rejected in Pierce County, the very first filing I've made in a 40-year career. And it was for the same reason. And where is that in the court rules? I read everything. And so, well, it's just something we do. Oh, and we'd like to have a copy of the death certificate, even though it's not required in the statute or the rules. So Mike, I have a question and a comment. The question is, what has to be done to get a unified court rules? Can the Supreme Court just say, these are the rules and you'll like it? You require a constitutional amendment? Well, crap. That's yeah. But even so, I know the courts, I had a decision whether or not to file this in King or Pierce County. They do not use the same e-filing system. It's insane. I mean, it's really nuts. This should be centralized to the state. So that's what has to be done. And now the observation is a shout out or me to fellow Governor Couch. The problem with having the ATJ board front the unified court system is that people do not care about ATJ clients. You know, who needs to push for a unified court system? Perkins Coie. You know, hey, legislature, this pisses off every lawyer in the state. You know, we got to fix this. And, you know, find a way to make the court clerks do the right thing. And
Thank
that's
you.
all I have to say about that.
Thank you, Governor Fay. Governor Ahern.
Okay, listening to all these comments and, you know, we got to make them do this, make them do that. My observation over 35 years of litigating is a big reason for the fiefdoms is funding. And the fact that, at least in a lot of the counties, the Superior Court, the clerk, they're all employees of the county commissioners. And they're the ones that make the decision. And funding is the primary or a major driver. I mean, just think about the pushback we got on the public defender standards from counties that were saying, we can't afford this. Well, you know, part of it is poor counties can't afford a lot of things. So to me, and it goes back to funding, and the state needs to fund more. And if we want better access to justice in our superior courts in the counties, the state has to fund it, period. Anyway, that's my thoughts.
Thank you so much, Governor Ahern. Governor Wen.
I agree with what everybody has said here about the uniform court. But somebody has to draft a constitutional amendment and also uniform court rules afterward. So once that's done, each of us has our connection. I would certainly advocate to the probably incoming Attorney General to pick it up as sponsored legislation from the Attorney General office. I think I know both the I don't know Adriano candidate, but I think the candidate out there would be willing to support it. And also we also have Perkins Coie, people who represents big law firm here. We can do it, but we need somebody to draft it first. And who's drafting it first? That's the question.
Thank you so much for volunteering to do that, Governor Wynn.
Yes, Governor Wynn, thank you so much. New committee for next year. Anybody else? Yes, Governor Rathbone.
Okay, I just want to make one more addition. So I think I see a lot of times we complicate things by saying, well, why can't something be a certain way? And at least as far as, you know, my personal experience in the superior courts and the separate offices and the lack of communication and sort of these underlying battles between these separate offices, it also is education. You know, are these judges being, I guess I did call them out. Are they being educated, you know, on these like basic principle issues to stop hundreds of thousands of dollars in attorney's fees on what I would consider a fairly straightforward matter? So, you know, I think part of it too, it takes buy-in from the courts. And how do you do that, right? Well, I'm pretty sure that there is some education standard for new judges. Are they getting, you know, are they getting the education that's required to make sure that they're, at least from the access standpoint, that they are educated enough to make those calls I'm trying to be objective, and just in a manner that serves the access to justice motto. So I would just like to add that. Thanks.
Thank you, Governor Rathbone. And Nancy Hawkins, our public member.
Hi there. We talked about this some time ago. And the issue, it's not like we just discovered this problem and everyone else doesn't know about it. AOC's been working on this for years. We can't just approach courts and start saying, well, why won't you do this? Look, it's so simple. And I get that it should be simple, but it isn't. And I think it was Tom hit it right on the head that it's a funding issue. The decisions were made years ago, decades ago, to invest in certain kinds of equipment and software. And people don't want to hear, well, we got to throw that out and you have to use Pierce County system or King County system, or, it's very complicated. And so the board should have the people from AOC who have been working on this for years come and give a report about how that process is going, what role we can play to help, because the problem has long been identified. It's not up to us to identify it. We know what it is. It's okay, how can we help? And, what have you done so far that could use our help, or, whatever. So I would say get it on the BOG agenda for an upcoming meeting to have AOC come and talk about it. Thank you.
Thank you. And I see Chair Cherry has his hand up.
I'm just
Sorry, Michael, I cut you off. Start again, please.
I'm sorry. Thank you for letting me
The bad terror
today, but I'm just amazed at this discussion. Not for any other reason than it is so anecdotal. The court doesn't care that one of you filed in Pierce County and had a problem, or that somebody else filed somewhere else and had a problem. Where is your data? That does not prove this is a widespread problem. You can't go to anyone and get their attention with that kind of storytelling. So I just encourage you to do what Nancy said, but also start a process of collecting the data of how often this is happening. And don't just pretend you can estimate the costs. Show people the costs. Thank you. I'll get off my soapbox now.
Thank you, Chair Cherry. Anybody else have any? Governor Couch.
So I just had one more separate roundtable thing, which is I haven't seen an update on this, and I'm wondering where we are on. Past Governor Cherry reminded me of this: the Practice of Law Board's proposal to do a test run of the sandbox proposal. I know we voted on this last year, and we're hoping to have something done earlier this year with request proposals, and it's kind of just been dead as far as I've seen.
I can give an update, and Michael Cherry, if you want to give an update, go ahead and put your hand up as well. It's been in the hands of staff. So we've been meeting internally to try to get alignment on how this would work, and draft something to share with the Practice of Law Board so that they can take that to the court. And Michael did put his hand up, so.
And that's correct, but we are 6 months since we presented this to the Board of Governors, and the Practice of Law Board is yet, as of today, has not seen anything from the staff. We've been asked a couple of questions, but we've been not being invited to meetings, and so we're just sort of waiting on getting something.
if it would be helpful to have a governor involved in this, I'm happy to volunteer to be that governor to support this and do work on this and do drafting and writing and all of that. Our current Madam Butterfly can appoint me if she wants to.
I would be happy to do that. Anything else?
This room is hot.
Well, we're probably about to adjourn, but before we do, I really want to thank all of you around this table today for really, I think it was a fantastic first day of the meeting. I think we had some great dialogue and discussion, and I just commend all of you for really showing up today. I also want to encourage folks to, it was mentioned earlier that some of our minority bar associations are struggling to see the value of participating with the bar association. And there's a history behind that that I will not go into at this moment, but I will talk about a possible solution. I really encourage folks who are liaisons to the MBAs to take it seriously. Connect with the leaders. You don't have to go to every meeting if you can't, but you should go to something. And you should reach out to the leadership, and you should know what is going on. And more importantly, you should be an ambassador of this board. So I'm saying this, and I'm probably going to keep saying it every meeting, because I want things to change. And the only way they're going to change is if everybody shows up and takes their responsibility seriously. I am not judging or blaming any individual person, but we can do better with our MBAs. And I'm really asking you to help me make that happen. Okay, I'm off my soapbox. And if there's nothing else for the good of the order, then I would like to adjourn, but there are going to be, recess. Yeah, no, I'm so anxious to have it all be over. Adjourn, done. We are going to be taking a photo, I understand, outside. So let's do that, and we will see everyone tomorrow. Thank you.
Can we leave our stuff on the table?
Well, you got to be there for breakfast. We have breakfast with the Washington Leadership Institute, which starts at 8. 8 starts at 8.
Good to go, 3 hours.
Yes, and then the meeting will start at 10.
Can we leave our stuff on the table? On this table? Can we
For
leave
the
our-
moment or for the night?
No, for the night.
Rex, will the room be secured overnight? Use your own judgment.